demonetization, opening another window to deposit Rs 500, Rs 1000 notes will be good. Here is why. www.financialexpress.com Demonetization, opening another window to deposit Rs 500, Rs 1000 notes will be good. Here is why today, 6:50 am. Apart from the debate over whether it was desirable, the government did all manner of flip-flops, given that this was the first such exercise anywhere in the world, and so there was no playbook to go by, though that may have been unavoidable. 7 months after demonetization, the controversies around it aren't going away. Apart from the debate over whether it was desirable, the government did all manner of flip-flops, given that this was the first such exercise anywhere in the world, and so there was no playbook to go by, though that may have been unavoidable. What was not was the time given for people to exchange their old notes, given the rush at banks. While the Prime Minister had first talked of people getting a longer period for the exchange, when the notification came out, it restricted this to December 30th. This was later extended for NRIs or for those who were not in the country between November 8th and December 30th. At the time of demonetization, many argued the government had no right to snatch away people's property. Since the government was not snatching away anyone's property, the argument was invalid. But when the window for exchange was limited, it was possible to argue that this is effectively what the government was doing. Indeed, the Supreme Court has invoked this very right to property in asking the government to open another window for people to make the exchange. Since the government is, in any case, tracking all those who deposit very high amounts of cash, especially if these are not in sync with their income profile, there is nothing wrong with accepting SCA's suggestion and leave this open to everyone. If the window is used to launder black money, it will be tracked in the same way that deposits made before December 30th were. Since this will mean more of the demonetized money will find its way into bank currency chests, it will also give the central bank one more reason to delay making public the figures of how much of the demonetized currency has come back. Read, post comments, visit website. Power of legislatures needs questioning. Here is why. www.financialexpress.com Power of legislatures needs questioning. Here is why today, 6:47 am. Articles criticizing 3 MLAs had been published some years ago in Ravi Belajya's He Bangalore and Anil Raje's Yelahanka Voice. However, instead of choosing the more appropriate recourse of litigation, the MLAs invoked breach of privilege. The Speaker of the Karnataka Assembly, K.B. Kolivard, sentencing two tabloid editors in the state to 1 year's imprisonment and slapping them with fines of Rs 10,000 each for breach of privilege appears indefensible and out of proportion with the offense. Articles criticizing 3 MLAs had been published some years ago in Ravi Belajya's He Bangalore and Anil Raje's Yelahanka Voice. However, instead of choosing the more appropriate recourse of litigation, the MLAs invoked breach of privilege. The Speaker authorized penal action for something that should have, at best, attracted admonition. While the sentencing is technically within the legislature's powers, whether the framers of the Constitution envisaged breach of privilege to lead to a prison sentence, a power usually exercised only by the courts, is open to question. The problem stems from the Constitution's provisions on privileges and powers of the legislature. Articles 105 and 194 were instituted to protect the freedom of speech and expression in Parliament and assemblies and to ensure that no one from the outside could exert undue influence, pressure or coercion on the functioning of the legislative bodies, to take part in the proceedings of a house of the legislature of a state. But these provisions are loosely worded. Article 194(3) states that the powers, privileges and immunities of a house of the legislature of a state, and of the members and the committees of a house of such legislature, shall be such as may from time to time be defined by the legislature by law, and, until so defined, shall be those of that house and of its members and committees. but surely none of the newspaper articles was either affecting the mass freedom of speech or their ability to take part in the proceedings of the legislature. Breach of privilege cannot be used to prevent any criticism of MLAs, MPs. The extent to which this can be abused was best seen in the case of Keshav Singh, who was, in 1964, sentenced to 7 days imprisonment by the Uttar Pradesh Speaker. Singh got bail from a two-judge bench of the Allahabad High Court, and this led to the assembly issuing warrants against not just Singh but also the two judges and Singh's advocate. When the matter reached the Supreme Court, it clarified that the powers of the assembly included the power to punish contempt. But the time has come for legislatures, parliament to define more strictly what exactly contempt of the House is and to codify the penalties for it, including the right to imprisonment. Instead of the matter being referred to a court, it would be in everyone's interests if legislature, parliament itself took the lead in the matter. A blatant abuse of power will lend momentum to a public demand for the abolition of the privileges altogether. Read, post comments visit website. Bank NPAs crisis, insolvency process can only get delayed if courts entertain appeals against RBI orders. www.financialexpress.com. Bank NPAs crisis, insolvency process can only get delayed if courts entertain appeals against RBI orders. Today, 6:40 am on June 13th, the central bank had identified a clutch of 12 accounts. This included Essa Steel, that were to be referred by banks to the NCLT, a decision that was justified given lenders had exhausted all other options to recover their dues. Indian promoters are proving yet again they will use every trick in the book to save themselves, even though they may be defaulters. Even before the National Company Law Tribunal (NCLT) could admit the insolvency case against Essa Steel, the company has moved the Gujarat High Court. It has argued RBI selection of 12 stressed exposures to be resolved via the IBC Insolvency and Bankruptcy Code is arbitrary. On June 13th, the central bank had identified a clutch of 12 accounts. This included Essa Steel, that were to be referred by banks to the NCLT, a decision that was justified given lenders had exhausted all other options to recover their dues. While the wisdom of the High Court will prevail, it would be very unfortunate indeed if the Essa Steel case isn't admitted to NCLT. That would be a very big setback for the initiative taken by the government and RBI to try and solve the bad loans problem, which is threatening to stall growth. There is a lot of taxpayer money at stake, backward 2 lakh crore in the 12 accounts, and while the promoters may argue RBI's selection of accounts is arbitrary and that the business is turning around, the fact is the company is unable to service its loans. If the High Court doesn't dispose of the case quickly, which is necessary for the NCLT to admit the case, it will become very hard for the lenders to recover their loans. Moreover, it will vitiate the environment, with other promoters also likely to start approaching various courts for similar relief. Should the case drag on after the next hearing on July 7th, the government as the owner of the banks should explore all legal options it may have, including, if need be, petitioning the Supreme Court on the need to ensure the NCLT process does not get delayed, derailed. While the circumstances of each NPA differ, it remains a mystery as to how many of these firms were able to borrow so much even after not being able to service their loans. There is little doubt the banks were lax in their evaluation and also helped evergreen loans. Also, in the Essa case, while financial institutions took big haircuts nearly 2 decades ago on a loan to the company, it is not clear if they got any recompense when the promoters sold their stake in the Hutch joint venture many years later. As former RBI Governor Raghuram Rajan had observed, many promoters believe it is their divine right to stay in control despite their unwillingness to put in new money. With the benefit of hindsight, tighter norms for prudential exposure limits to groups and companies would have helped prevent corporate India from being as over-leveraged as it is, almost posing a systemic risk. The very liberal norms were intended to promote industry and growth, but have ended up making the banks bankrupt. Indeed, if there were norms for blacklisting defaulters, many of the groups RBI has identified would never have been able to run up the kind of debt that they have. It would be a shame if the Gujarat High Court allows the case to drag on, thwarting the attempts of lenders to get back what is rightfully theirs. Read, post comments, visit website.